Hello, and welcome to another coronavirus edition of Professional Responsibility. As you'll note, out of abundance of caution, I am wearing a protective mask. You never know when those little buggers will sneak up on you and try to pollute your precious bodily fluids. In this lecture, I will discuss how the attorney-client privilege applies to organizational clients, including corporations. Never tell a lie, and don't be a crook. As you know, the attorney-client privilege provides that certain communications between an attorney and a client are protected not only by the fiduciary duty of confidentiality, but also by an evidentiary privilege. Attorneys must always protect the confidentiality of information obtained in the course of representing a client. But sometimes attorneys must disclose confidential information. For example, the process of fact discovery in litigation literally consists of the mandatory disclosure of confidential information. By contrast, information covered by the attorney-client privilege is absolutely protected from disclosure, unless an exception applies. However, the attorney-client privilege is narrow. It only applies to confidential communications between an attorney and a client for the purpose of obtaining or providing legal advice. Notably, the attorney-client privilege belongs to the client, not the attorney. Accordingly, only the client can waive the privilege. The attorney cannot disclose privileged information without the client's informed consent. But when an attorney represents an organization, the client is the organization, not its agents. When, if ever, should the attorney-client privilege attach? After all, the attorney necessarily communicates with the organization's agents, who are not themselves the client. And who can exercise the privilege? After all, the decision to assert or waive the privilege is also made by the organization's agents, who are not themselves the client. The scope of the attorney-client privilege is determined by state law. In some states, the privilege only extends to communications between an attorney and the members of the control group of an organization. But in Upjohn v. United States, the Supreme Court adopted a broader definition of the attorney-client privilege, which applies in all federal courts, and has also been adopted by the overwhelming majority of states. Under Upjohn, the attorney-client privilege applies to confidential communications between an attorney and the agents of an organizational client when 1. The communication is for the purpose of providing legal advice to the organization, 2. At the direction of the management of the organization, 3. Concerning a matter within the scope of the agent's employment, and 4. The agent knows the purpose of the communication is providing legal advice to the organization. Under Upjohn, a communication between an attorney and an agent of an organizational client is protected by attorney-client privilege whenever it is for the purpose of providing legal advice to the organization, no matter what role the agent plays in the organization. Accordingly, a communication with the CEO might be protected, but so might a communication with an intern or a custodian, so long as the communication is for the purpose of providing legal advice to the organization. But remember, the privilege belongs to the organization, so the organization makes the decision whether to assert or waive the privilege, and the management of the organization can make the decision whether to assert or waive the privilege based on the best interests of the organization, not the agent. Indeed, the management has a fiduciary duty to act in the best interests of the organization rather than the agent. As a result, when the agents of an organization provide information to an attorney representing the organization may later disclose that information even if it harms the agent. Indeed, it is often in the interests of an organization to sacrifice its agents in order to benefit itself. This can be a problem if the agent believes the attorney represents them, as well as the organization, which could create an attorney-client relationship, an attorney-client privilege belonging to the agent. In order to avoid creating an attorney-client relationship with the agents of an organization, attorneys often provide what is known as an Upjohn warning. Here is a typical Upjohn warning. The company has retained our law firm to investigate this matter. We are meeting with you to learn more of the facts about the matter so we can give legal advice to the company and to prepare for potential litigation. In our role as attorneys, we represent the company only. We do not represent you or any other employees personally. If you want a lawyer, you will need to hire your own. Our interview is confidential and subject to the attorney-client privilege. This generally means that no one can force you or me to disclose in court what we tell each other today. Understand, however, that the privilege belongs to the company, not to you personally. In the future, the company may decide to waive the privilege and disclose the information we learn in the investigation. If the company chooses to waive the privilege, it can do so without your consent and without telling you. For the company to maintain its attorney-client privilege over the information from this interview, it is important that you not share the substance of our interview with anyone. Keeping this interview confidential also will protect you if our opponent ever decides to interview again about what happened. The company will not tolerate any retaliation or reprisals against you for cooperating with our investigation and telling the truth. On the other hand, failure by employees to cooperate with the investigation may result in company discipline, including possible termination of employment. Do you understand? Do you agree to keep this interview confidential? Do you have any questions before we begin? Upjohn warnings are often called corporate Miranda warnings because they are intended to notify the agent that any statements may be used against them if it will benefit the organization. If the attorney for an organization fails to provide an Upjohn warning, it is possible for an attorney-client relationship to exist with the agent. But courts tend to be reluctant to find an attorney-client relationship even under those circumstances, often asking whether the agent's belief that an attorney-client relationship existed was objectively reasonable under the circumstances. Is that the right standard to apply? Or should courts insist on an Upjohn warning and informed consent? Why might attorneys representing organizations be inclined to avoid giving an Upjohn warning? Might it affect an agent's willingness to provide candid advice?
I can tell you that my people always did what they were told.
Nixon now, Nixon now, more than ever we need Nixon now, Nixon now, Nixon now, more than ever we need Nixon now. Coming up east, coming up strong, he's following through. Nixon now.